This is Camila Scaro, freshman student of the City University of Pasay School of Law. Our subject is Philosophy of Law and our assigned topic is Social Development and Legal Evolution.
Individualism is the moral stance, political philosophy, ideology, or social outlook that emphasizes the moral worth of the individual. Individualists promote the exercise of one's goals and desires and so value independence and self-reliance. Individualism was the prevalent philosophy in the 19th century. Then a new social discipline replaces the individualism, and the emergence can be chiefly traced to the consequences of the Industrial Revolution. The Industrial Revolution is now also known as the First Industrial Revolution. The First Industrial Revolution is actually the transition to new manufacturing processes in Europe and the United States in the period from about 1760 to sometime between 1820 and 1840. The following are the consequences of the Industrial Revolution which influenced the emergence of the new social discipline. The urbanization and standardization of the life of the masses, the disastrous effects of an uncontrolled capitalism supported by a philosophy of economic liberalism, the rising revolt of the dispossessed masses forcing the state to intervene in order to mitigate the worst injustices, and the growing international friction leading to a new militant imperialism which demands the absolute and thorough military, economic, social, and mental organization of the masses. As regards the ultimate purposes towards which this discipline is used, there is indeed an irreconcilable conflict between rival philosophies of life. But the technique of modern life, as a consequence of the Industrial Revolution, demands social discipline, the coordination of individuals as the only alternative to chaos. The legal theory has played an important part in the development of these new ways of social life, and the most representative of these theories have been developed by Darwin, Spencer, Comte, Durkheim, Duguid, Gurke, and Haureau. Darwin and Spencer. Charles Darwin and his contemporary philosopher Herbert Spencer may not have had much to say about modernity, but they certainly had a lot to contribute to it. Darwin was a scientist and hence was primarily concerned with the empirical study of the natural world, while Herbert Spencer is inclined as he was toward philosophy and the humanities. He was chiefly interested in the meanings and implications of the work done by the likes of Darwin. In short, he took the additional step of wondering what ought to be and not merely what it is. As much as Darwin's writings were descriptive, Spencer's were prescriptive. Utilitarianism is one of the most powerful and persuasive approaches to normative ethics in the history of philosophy. The classical utilitarians Jeremy Bentham and John Stuart Mill identified the good with pleasure, so like Epicurus were hedonists about value. They also held that we ought to maximize the good, that is, bring about the greatest amount of good for the greatest number. Utilitarian principles are put by Spencer on a different basis, by his application of the biological discoveries of Darwin to ethics and law. Added to those are individualistic and ethical ideals, which, an afterthought, arrive at results very similar to those which Kant had formulated a priori. Utilitarianism in normative ethics, a tradition stemming from the late 18th and 19th century English philosophers and economists Jeremy Bentham and John Stuart Mill, according to which an action is right if it tends to promote happiness and wrong if it tends to produce the reverse of happiness, not just the happiness of the performer of the action but also that of everyone affected by it. Simply stated, utilitarianism means that actions are morally permissible if and only if they produce at least as much happiness as any other available action. Jeremy Bentham, a proponent of utilitarianism, is also an early defender of economic liberalization, freedom of expression, the separation of church and the state, women's rights, animal rights, the right to divorce, abolition of slavery, capital punishment and corporal punishment, prison reform, and decriminalization of homosexuality. Issues of which are very relevant in the present time, and remember, these could be traced back in as early as 1789. Utilitarianism can be broken into two parts, a theory of what is valuable and a theory of what is right action given what is valuable. A theory of what is valuable, it says that the only thing that is valuable in its own right is happiness in the absence of suffering. For example, the value of money because it gives people happiness. A theory of what is right action given what is valuable is the one that maximizes or produces the most of what's valuable, or simply stated, that which maximizes the value. For example, a doctor have a 5 dose of medicine and there are 6 patients, 5 of those in need of 1 dose each in order to survive, while the 6th patient need all the 5 doses of medicines in order to survive. Utilitarianism will tell the doctor to give the 5 doses of medicine to the 5 patients. Why? Because he will save 5 people instead of 1. But that would change if the 6th patient happens to be the mother of the doctor. Of course, the doctor would rather choose to save his mom than to save the 5 patients. And that is one of the problems encountered by the utilitarianism. As conditions of existence vary among different people and times, so do the principles of ethics and law. Spencer's maxim of law is, each man may do what he likes, provided he does not injure the equal freedom of others. As for these value assumptions, Spencer's theory combines a number of ideals which other legal theories propound simply in opposition to each other. With Kant, Spencer shares the appeal to man's social duty. He deduces it, however, from biological, not from metaphysical principles. With Maine, Comte, Durkheim, and Duguid, Spencer shares the belief in the progress of social through increasing social organization and specialization. With Comte and Duguid, Spencer shares the belief in the supremacy of social duty over egoistic impulse as a matter of biological evolution. On the other hand, Spencer shares with Kant, Bentham, and Humboldt the aversion against any active social function of the state. With a host of exponents of the natural right theory, from Locke to Jenney and the American Constitution, Spencer shares the postulate of certain fundamental individual rights. As later Duguid, Spencer is inevitably led by his biological conception of society towards an organic idea of the community, but shrinks from thinking it out to the end owing to his individualistic fate. Comte, Durkheim, and Duguid. Comte's scientific positivism is based on the empirical as opposed to the metaphysical method. All reflections must, according to Comte, be derived from experience and observation, from facts, and not from preconceived ideas. Durkheim, by his distinction between collective and individual consciousness, came to investigate some of the factors of social needs and action. And for Duguid, law as an aspect and requisite of social solidarity is a fact. It is a rule which men possess not by virtue of any higher principle whatever, good, interest, or happiness, but by virtue and perforce of facts because they live in society and can only live in society. The duty to maintain social solidarity is also a fact beyond discussion. Duguid rejects an idealistic tendency in Durkheim's work, the assertion that immanent in the experience of social community, there are objective ideals which surpass experience and manifest themselves in objective realities. As a jurist, Duguid has one object of all, to establish a rule of law, absolute and incontestable, and at the same time objective, freed from the arbitrariness of human will and lust for power, which so often assumed the mantle of the state's sovereignty. A large part of his work is devoted to an attack on the myth of the state sovereignty and the theories which personified and sometimes deify the state. Duguid reaches conclusions viewing all individuals, whether exercising public functions or not, as parts of a social organism with the function of helping the will of others as well as their own. By public service, he rejects the whole conception of private right. The idea of social function crowds out the conception of subjective right. Duguid often repeats a saying by Comte that the only right which any man can possess is the right always to do his duty. Duguid's 3 rules of conduct are framed in terms of imperatives. Number 1, respect every act of individual will determined by an end of social solidarity. Do nothing to prevent its accomplishment. Cooperate as far as possible toward its accomplishment. Number 2, every individual ought to abstain from any act that would be determined by an end contrary to social solidarity. And number 3, do nothing to diminish solidarity by similitude, or social solidarity through division of labor. Do everything materially practicable for the individual to increase social solidarity in both its forms. Gurke's theory of corporate personality is familiar to the Anglo-Saxon legal world, above all through its introduction and championship by Maitland. Its basic theme is the reality of the group personality as a social and legal entity, independent of state recognition and concession. It goes together with the general theory of law. The principal points of Gurke's Genossenschaft's theory developed from these premises are these. Number 1, the life of an association does not depend upon the state recognition. Number 2, a juristic person comes into being not by a multitude of individual contracts, but by a collective unilateral act directed towards the creation of the juristic personality. And number 3, relations between the state and corporate bodies within it. By a piece of very strange reasoning, Gurke attempts to reconcile 3 apparently irreconcilable ideas. Number 1, the sovereignty of the state. Number 2, the Rechtsstaat idea. And number 3, the autonomy of corporate life within the state.